The Honorable F. Rand Wallace, Judge presiding. All persons having business before the court draw near, to attention, you will be heard. May God save the United States of America, the state of Florida, this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. Previously introduced, I'm Rand Wallace. Joining me on the panel here this morning, to my right and your left, is Judge Brian Lambert from Marion County. And to my left and your right, Judge Paige Kilbane from Duval County. Please, when you're sitting there, please go ahead and proactively silence any noise-making devices so it doesn't distract the other party from making their presentation. And I will assume, Mr. Grassley, that you would like 5 minutes of rebuttal unless you tell me otherwise.
Yes, sir.
And the case we have is Chad Grimm versus Terry Michelle Grimm. Terry Yeomans, and the case number is 2024-1637. Mr. Grassley, you may proceed.
Good morning. Is this working?
It is, yes.
Okay, good. I'm vertically challenged, so I never know. Good morning. May it please the court. I'm Bill Grassley from Jacksonville on behalf of Chad Grimm, who is the appellant, former husband below. It's difficult to know where to start with the problems that we have with the order under review, which is an order denying my client's supplemental petition for modification of alimony, and based upon that, a finding of contempt and award of attorney's fees to the former wife, the appellee here. I've raised those two last because they are all predicated on the order that we're here on to review, the order denying the supplemental petition. Once this court reverses that order, the finding of contempt must be reversed as well, and the case returned to, and the attorney's fees must be returned to the court as if those had not been entered. And I've cited those cases in the brief that talk about that. The errors in the final judgment are both legal and factual, lack of facts, and a misinterpretation of undisputed facts. And we've cited in the brief the cases that say a court cannot just arbitrarily reject unrebutted evidence. The first error was the trial court deciding that my client knew that he was going to not get a bonus in 2019 for the 2018 work that he did at Lode King. And just as context for this, my client has a 5-year degree in landscape architecture. And that's how he met Mr. Chupp, who was the president of Lode King, which is a one-stop all shopping to build franchises according to
Mr. Grassley, it appears to me that the trial court, obviously, I think we had 2 trial judges, correct, presiding over this case through to its, or was it just one trial judge?
Just one in the 2 days of hearing that...
Okay. But the trial judge appeared, I'm reading, I don't know, the tea leaves, maybe not too hard, but made a judgment on credibility.
Yes.
Is that correct?
And basically what she did was not believe anything my client said about anything. And in the process...
The trial judge did not use those words, obviously.
I'm sorry?
The trial judge didn't use those words, didn't believe your client about anything your client said, but judged the credibility, correct? And we give deference to the trial judge as far as judging of credibility.
Of course we do. And if that was my only argument, we wouldn't be here. I would not have taken an appeal on that ground. The problem with the judge's determination is she's making assumptions about facts that have no evidentiary basis, claiming there's evidence that shows one thing or another that is not there. The first one being an attack on the consent final judgment that the parties entered into, made a finding that my client knew in December 2018 when the consent final judgment was entered and he agreed to the $10,000 a month for 10-year durational alimony, that he was not going to receive a bonus from Lode King, which is his employer. There's no evidence to support that. There's no basis on which the trial judge is authorized to make that type of a...
Wasn't the overriding question the reduction in income?
Yes.
And your client, I guess, would stop receiving commission, but received an increase in income or salary, correct?
No, sir. I'm sorry, that's not correct. What the pattern was, from the time that he went to work at Lode King, he went there as a landscape architect and eventually worked his way up to handling all their development and was the COO. He got an annual salary at the time of the consent final judgment of $250,000. The bonus that was paid at the beginning of 2018 for 2017's work was $140,000. He knew that the company was doing well, and the bonuses were, at that point, routine. And when he entered the consent final judgment in December, he anticipated getting at least $100,000 bonus, which was paid in January or February of the following year in 2019. That's the way that the consent final judgment was set up, and that was the basis for it. As soon as February rolled around and he learned nobody was getting bonuses, this wasn't just him, despite the fact that the company was prospering and solvent, he then paid without having enough money to do so. He filed his supplemental petition in June saying, I can't do this. I have children in college that my wife and ex-wife and I have agreed to put through college, and all of a sudden I'm $100,000 short of what I thought I was going to be.
But Mr. Grassley, and to Judge Wallace's point, this credibility, the trial judge is in that position. You said that Mr. Grimm knew that the company was doing well. And my recollection may be incorrect, but I thought it was that the company was not doing as well in 2018 as it had done in this once-in-a-lifetime project in 2017. There were other indications that, I believe the gentleman that you mentioned that he had met and who was the CEO of Lode King was getting older, he had no succession plan, things of that nature, so that for him to believe as COO at that point that the company was doing well and he anticipated a bonus similar to that he had received, it was that the court based its credibility determination off of, was it not?
No, ma'am. I'm sorry. The court made this up. There's no other way to put it. There's no evidence about this except that he historically had been getting bonuses. Yes, you're right. There was a bigger year the year before when he got the $140,000 bonus, but he anticipated getting $100,000 because that was consistent with all the practice. If we turn this around and he wanted to claim, well, bonuses are not, shouldn't be considered as part of my income if we're setting alimony vel non, then the legal answer is if they're routine and reoccurring, then they are considered part of your income. He considered that he was going to get a bonus, and it turned out he was wrong. And from that, my client is supposed to have, what he did was he went out and depleted all of his assets. He continued to make payments, the alimony payments, until he lost his job in February of 2021. And at that point, this person who has gone from being his own boss doing landscape architecture for real estate developers, commercial real estate developers, to the only manufacturing type job he'd ever had, which was with Lode King, and he finds himself with a $120,000 a year alimony obligation, 2 children in college that he and his ex had agreed they were going to help, and then turns around and has zero income. One of the, I'll say irony because that's as charitable as I can put it, one of the ironies of this whole theory advanced by the wife, former wife, and accepted by the trial judge is that somehow my client hustling and working the equivalent of 2 full-time jobs in 3 different small businesses that he's trying to grow was because the only jobs that he could find with his landscape architectural degree were W-2 jobs paying between $100,000 and $120,000 a year. Well, if we take that at face value, which there's no other evidence, no one ever suggested, oh, with his experience he could get twice that much money. There was no evidence. The only evidence was my client saying, I looked, and I can do better than that on my own. And he has consistently, but not always, has earned more. But what the trial judge fundamentally found was by peeking behind what was actually going on with the consent final judgment, which is this is what the parties agreed to, and this was what the situation was at the time that they entered into with financially, and that immediately changed as soon as he didn't get a bonus, and then it fatally changed when my client lost his job. income figures that the trial judge recites in paragraph J of the order under review leave off the 2015 through 2019 figures, but they were all consistent with him getting a bonus, as I discussed before. The other part of this is that what the judge said and held was, well, you knew that you weren't going to get a bonus, but you agreed to something you couldn't afford, and you're stuck with it. This is not a permanent change because your alimony, your income keeps fluctuating. Well, of course it fluctuates. On page 3 of my reply brief, I point out that going from the $352,000 that he was earning in 2018, that each year thereafter, 2019 was a 16% reduction, 2020 was a 21% reduction, 2021 was a 13% reduction, and 2022 a 61% reduction, and the trial in 2023 was projected to leave him with a 56% reduction in income from at the time the final judgment was entered. So the concept that he can lose all of his income, and instead of taking a job that would have if he had taken a job for $120,000, what the judge would not have been legally allowed to say, well, you have to pay 100% of your income to meet your alimony obligation. And that's essentially the reasoning that this order under review takes is, well, you agreed to it knowing that you didn't have the money, so you're stuck with it. The change is permanent. We cited to the, I think it's Allaire, A-L-L-A-I-R-E case, that talks about if this change is going on for more than a year, then that's a permanent change. This judge has then projected on top of this all of these potential projects that he's working on that may bear fruit in the future. And my clients certainly hope so. Nobody would choose to be in this position. I mean, the idea that that these letters of intent, which are an offer to sit down and let's make a contract, that somehow the fact that one of them said we'll pay $29 million for this property, the judge bought the argument that means those funds are readily available to you and you can use it for alimony. I direct the courts.
That's not necessarily what the judge found. Is it a fair reading for the judge to say, well, you think you're in the position to buy something worth $29 million, you apparently have more money and more income and more assets than you're letting on here, and I therefore find your testimony not to be credible when you're claiming that you don't have the income to pay your agreed upon alimony.
No, sir. You have just pointed out the definition of an abuse of discretion.
I have.
You did.
I should write that down. I guess I never knew that before.
Of course you did. My point is that the judge said in the order under review, well, no mention of third-party funding is mentioned in these letters of intent. The only evidence about how this business works came from my client. He's the general partner of a couple of these entities, which means, and he bought into it by sweat equity, which means that he's doing the work and he's got investors. If he had $29 million at his disposal to pay alimony, we wouldn't be here. I mean, this is, it's a reduction to absurdity argument. There is no factual basis that this judge could have said, well, if you've got the ability to do this, then you can pay alimony. If he's got the ability to do this, that's because other people are putting up the money and he's doing the work. The entity, Kalita, I think it's called, that caused the problem with Mr. Chupp and led to his termination, apparently, is one that he bought in by sweat equity. He didn't put any money in. To keep current as long as he could on his alimony payments, he depleted his 401k, sold every investment stock, whatever he had, borrowed heavily against his life insurance policy. He had zero unsecured debt, or close to it, at the time of the consent final judgment. And by the time of this trial, he had $375,000 worth of unsecured debt. He's definitely juggling, and he's not juggling to try to prevent himself from paying the alimony obligations. He's trying to survive. The judge, let's see, that was paragraph J, and at the top of the next page is paragraph K. discusses the evidence that the wife presented showing that he was somehow hiding personal expenses in his businesses. There was no such evidence. There was only the insinuation of wife's counsel. She didn't testify about any of that. The actual evidence that shows all of this, including his treating any personal payments as in-kind distributions to him from his businesses, the wife's 28, Exhibit 28, was just this amorphous list of all transactions. My client produced all of his financial records, bank records, whatever they asked for, and wife's trial counsel's paralegal put them in a spreadsheet, and at the first day of trial, she had to admit that she didn't have any idea what these things were or the source of any of these deposits, and she made assumptions that they were his income. Well, they weren't. They were from borrowed funds and all the other things that I just mentioned. Exhibits 10 through 14, beginning on page 1088 of the record through the last exhibit starts at 1166, shows his income, and it shows the in-kind treatment for any funds that he expended from his businesses for personal matters. Those are attributed to him personally. And the court found that he had income, and they found it in an amount, like I said, that was significantly reduced from the amount of income he had in 2018 when the consent final judgment was entered. And so that is, in fact, a permanent change of circumstances. And there is no evidence to support the finding that somehow there was evidence that he was hiding his income. If you look at the exhibits I just directed your attention to and look at his testimony, the judge...
Mr. Grassley, you're in your rebuttal time.
Okay. Paragraph Y repeats this falsity and inaccuracy, claiming that he didn't present any evidence. Well, she chose not to believe it, but there is no other evidence. And we've cited that in the brief as well. The judge cannot arbitrarily reject unrebutted evidence. The wife did not put on any evidence that he was hiding money even after he had gone through her exhibits, and the exhibits that I just mentioned detail what was personal and what was business. Thank you, Judge.
Mr. Korn.
Thank you, Your Honor. I please the court. Michael Korn, Korn and Ziemer, Jacksonville, for the appellee, Terry Yeomans. Judge Cobain, you were right, by the way. Counsel disagreed with your correct analysis of what exactly the judge heard and the credibility determinations that the court made. So I wanted to just clear that up straight away out of the gate. So we have a case here where the husband agreed in the consent final judgment to a 10-year durational alimony payment, and there were very strict and specific reasons how it could be modified. Nothing dealing, by the way, with the wife, although at the trial they tried to claim that somehow she got more than she needed. That was a red herring, of course. What were the grounds that he could get modification? Had to be an involuntary change, had to be a permanent change, and it had to be material change, all of them. So what happened here? First, counsel's contention that it was undisputed that the Lode King business model was doing fine, and he had every reasonable expectation that he was going to get a bonus going on into the future, is not supported by the evidence. In fact, it's totally contrary to the evidence. The extraordinary bonus that was paid because of the Lode King work on the AMC Theater project was, in fact, extraordinary. And the court made a correct finding that as the chief operating officer of the business, he knew he had access to all of the financial information. He knew how the business was going. He knew that they were losing employees. He knew that that project was a once-in-a-lifetime deal. In fact, one would suggest that one of the reasons that he set up that Orbalate venture while he was still at Lode King and had the $100,000 paid to it was because he could see that perhaps I needed to have some other potential sources of income that wouldn't conflict with Lode King. And therein lies the problem on voluntariness. Because as the Vasquez case, which we cited in our brief, says, when somebody takes action that causes them to lose their job. In that case, Mr. Vasquez was apparently an abusive employee in the workplace. That's not what happened here. Here, we have a situation where Mr. Grimm decides he wants to go into business and set up these Huey Magoo chicken places. And he gets a 20% interest in that. Huey Magoo is a customer of Load King. And he even tells Mr. Chubb, oh, by the way, I can't deal with pricing or margins on these deals because of my role at Load King. No surprise 2 weeks later that he's terminated. So this idea that somehow Mr. Grimm was in this bubble of non-knowledge about where Load King was going, A, about his own corporate business model, and secondly, that he had no idea that perhaps going into the Kalita joint venture would somehow jeopardize Load King employment is just simply not true, and the court didn't believe it. And Judge Wallace, you pointed out early in your questions to counsel, the whole issue of credibility was, you know, Mr. Grimm can say whatever he likes, he can testify as he chooses. The court is not bound to believe it, and the court didn't believe it, just quite simply. So we have a situation where under Vasquez, there the court said, no, you led to your own termination. It's not, this wasn't a voluntary act. Similar principles apply here. And then we have permanency. And although there were certainly some dips in his income that were able to be shown, the trial court correctly found that they weren't necessarily permanent. Why do we say
So let me ask, in the final order, the judge cites to a case from the first DCA called Gibbs versus Gibbs.
Yes, Your Honor.
It says the trial court in Gibbs found, based on banking records and other evidence, that the former husband's expenditures on discretionary items, debts, and contingent obligations rather than alimony rendered his claimed loss ability to pay not credible, and that his, quote, lifestyle and prospects were completely at odds with his claim of reduced circumstances, and thus the modification was denied in Gibbs. And the trial judge here says the evidence in this case is basically shows the same. I note with, I don't know if irony is the buzzword today for this case, hyperbole was the last case. I note that you and your opponent were the attorneys in Gibbs.
Yes, Your Honor.
The appellate attorneys. Was the trial judge here correct that Gibbs has the similarities to this case and supports this ruling, or overread of Gibbs by the trial judge?
No, actually, Your Honor, with all due respect, Gibbs is very instructive and highly predictive of where this case, I think, ought to turn out. Why? Well, Mr. Gibbs, in that case, was basically living a rather comfortable, if not upper middle-class lifestyle. He made every expenditure he wanted. He played as he wanted. He lived as he wanted. The only thing he didn't want to do was pay his wife, and that he chose not to do. And then he claimed he didn't have the income to do it. He had remarried a lot of, if I recall the exact facts, Your Honor, I had the wife in that case. Counsel had Mr. Gibbs in that case. And if I remember the facts, Mr. Gibbs had remarried, and there were some back and forth about, well, the house is now in the wife's name, and this asset was in the wife's name. So, to your question, is Gibbs illustrative and instructive in this case? Absolutely, because it belies his claim that I'm scrambling, I'm doing everything possible to make things right. Well, he did everything possible here, and again, I don't fault necessarily that the fact that he spent $47,000 in one of the periods as set forth on the exhibits to pay for the child's education at American University, paid for the son's schooling in Middlebury in Vermont. But he also didn't deny himself anything either. And that's where the Gibbs, in this case, I think, kind of come together.
Well, the trial judge here seems to kind of tie Gibbs together, saying, well, the former husband in the instant case is spending a little over $21,500 per month in personal expenses, which I take from that the trial judge says, well, if you can do that, then your income must actually be higher than you're expressing to me as the trial judge, and therefore, if you have the ability to pay that monthly, you certainly have the ability to have paid some of that money towards the $10,000 that you agreed to pay.
Yes, Your Honor.
Is that a misread or an overread by me here, too?
No, sir. I think it's spot on. I mean, it's a matter of choice here. In other words, in Gibbs, the husband chose to make expenditures, buy things, spend money, and he just chose not to pay his former wife. The same thing can be said in this case. After he loses the Lode King employment, does he pay her $100 a month? Does he pay her $1,000 a month? He pays her zero, zip. And the Wilson case, which is cited in our brief, say, when you're seeking, equity from the court, you got to have some level of good faith. And there was no good faith there. He sends her a text after his not unexpected termination from Lode King. This is the last check you're going to get. He still went ahead and, was insuring his daughter's vehicles and paying for college and, starting new businesses, buying in. It wasn't just Kalita where he did get a sweat equity interest. He bought into several other ventures, one where he was trying to develop a large apartment unit complex in Jacksonville, the Ramona Project, where he put $60,000 into it, got 30 of it back. Did he even decide, well, maybe I ought to send something to the wife? Zero. So the matter of choice, coupled with the issue of no permanency, because counsel denigrates what the court found about the projects that he was working through this other entity called Dynamic Family, where he's literally all over the country. He's got projects in Napa Valley. He's got projects in Maine. He's got a project in the Bahamas. He's working stuff in Fernandina Beach, Florida. When he makes the decision, I don't want to be a W-2 employee anymore. I don't want to be a slave to that kind of corporate lifestyle. I want to do my own deals. Well, that's a choice. But the choice has consequences, and the choice says, I make that choice, but it's at the detriment of someone who I have a legal obligation to, and that's my former wife. So what's interesting here, too, and I was thinking about this, he says he gets into these ventures, whether it's the 20% interest in Kalita or it's the 3 Key Hospitality where he has other partners, and what did they say? We're not going to take any money out of any of these projects when they start performing, nothing. We're going to keep investing it back into the business. We're going to build it, and then we're going to sell it. When are you going to sell it, he's asked. Probably 5 to 7 years, maybe 10 years. So he's building what he hopes to be, if he's correct and successful, a very nice little nest egg, coincidentally about the time that the durational alimony period is going to end. Now, whether that's just coincidental, one can say or not say. But ironically, and this was the thought, the wife is now the very silent and very involuntary partner in his business now, because she is, in essence, by not getting the alimony she was supposed to get, she's kind of funding his ability to defer income, to do these deals, to say, yeah, we're going to plump all this money, we're going to develop these Huey Magoo restaurants, and I'm going to do fine when we sell them, knock wood, in 5 years, 7 years, 10 years. The testimony varied as to which asset we were talking about, which entity. But she needs that money today. That money wasn't just something to have around. She's driving a vehicle where the undercarriage was being held together by wire because she could not afford the repairs. So we have a lack of good faith on the husband who was paying her nothing. Even at the end of the first day of trial, the trial started in June of 2023, and he deigned that, maybe I'll pay her something. So I agreed to pay about $1,500 a month because he knew that the trial was going to get continued. Ultimately, the second phase started in October of that year. So he made a couple of those payments, and guess what? Those stopped too. So what have we got here? We have it's not a voluntary change. It's not a permanent change because in addition to the fact that he does have that $110,000 income on an annual basis from 3 Key. Originally, he wasn't. And then whether that was coincidental with Ms. Mello leaving 3 Key literally during the trial of this case, she was the former Lode King employee who came with him when he left. She and he also went to one of those personal empowerment seminars in Las Vegas during the period. But it was undisputed that he was then receiving $110,000 annually from 3 Key to work those projects. Plus, he has all the dynamic business. Plus, he has the Kalita, whether you impute or not. I heard something interesting too. It was almost as if it was the wife's burden to show that he had other jobs that he could go to. This wasn't an imputation case. This wasn't a situation where she had to somehow prove that he was not employed to the fullest. He made that choice from the get-go. He said, I don't want to be a W-2 employee anymore. Well, that's fine. That's his business, but he has legal obligations. Every other obligation or desire that he wanted was getting funded. Whether he was borrowing money, whether he was depleting assets, whatever counsel thinks the source of these funds were, those were choices that he made. And the one choice he decided not to make was, especially after the Lode King, no, my choice is I don't pay her. That's not sustainable. And the trial court saw through that, in our opinion. A couple of things that I wanted to address from counsel's argument. When we go back to the actual, what was interesting, and this is perhaps one of the tricky parts, is he files, the consent file judge was late December 2018. June of 2020, so about 18 months later, while he's still at Lode King, that's when he files his petition for modification. And there's nothing in there, it just says my income's down. Didn't track any of the tests that were required under the consent file judgment. My income's down. He's still at Lode King. Now, whether that bears into this, I had no idea. I was shocked that I was fired. Kind of reminded of Casablanca. He was shocked at conflict. Yeah, shocked. That's right, shocked. Your winnings. He was shocked that he was terminated by Lode King, and now he claims I had no idea I wasn't going to get a bonus. Well, the court saw through that too. The court even said in the order, I could have made a finding almost comparable to a directed verdict, partial directed verdict, that as to the period of 2020 and 2021, he never even met his burden. He didn't even plead for his relief. His papers didn't even make the pleading that would have been necessary had he had the proofs to prove them. But the order that says, well, since everybody got so into the facts and the math, we'll take a look at his math. And his math was based on his own discovery materials. And ironically, husband says he wants relief because his economics and his records are so opaque, it's difficult to figure them out. He's got monies moving from one to another. If you look at especially Exhibit 28, you'll see undifferentiated Venmo transactions. Now, I'm not a Venmo person. Clients even say, can I pay you through Venmo? I say, no, a check is fine. But Venmo, you can't trace where the money went, where the money's going. There were tens of thousands of dollars of those types of transactions if you look at the exhibits. So an attack on the analysis of the financial information that was obtained through discovery is just not forthcoming. It's not going to provide this husband any meaningful relief here. Just simply not. Credibility does matter. Pleadings matter. And the trial court saw that. And the trial court, through 2 separate trials, and the trial court was very active in this trial. If you look at the transcript, the trial court was engaged, asked questions if there were concerns or questions that she had about a particular area of inquiry. She asked about them. So this was not a judge who just sat back and did nothing and then entered some order later. She was very much engaged in this trial.
Let me Mr. Grassley says as to his second and third issue, that if the final judgment here is set aside, those would follow as a matter of course that they should be set aside. Flip argument to you. So if this is affirmed final judgment, then the contempt and the attorney fee, the contempt order, the aspects of the attorney fee should be affirmed for the same analysis that you're putting forth to us?
Absolutely. Plus, even if, well, first, Your Honor, yes, but I think it's even more strong than that for the wife, especially on the fees, because, of course, fees are determined based on not prevailing party, but 6116 teaches us need ability to pay. So even if she were to somehow have lost, she was entitled to a fee, and there was no question about it. And ironically, Judge, at trial, the husband's counsel stipulated that the rates of wife's trial counsel and her paralegal were reasonable, and agreed that the amount of time spent was reasonable and necessary. So Your Honor is right on one thing. Yes, it does flip, but I think the flip even strengthens our position as to the fees. Now, what about the contempt? I go back to that 2021 period of time, where he hadn't even pled yet. I don't think that a mere finding that he doesn't get relief automatically wipes out the contempt. I think that minimum you'd have to have some type of a remand to determine exactly what he has paid. So affirmance, as Your Honor I think correctly observes, does require affirmance of the fee award, and it requires affirmance of the contempt finding, and also respectfully requires an award of appellate fees as well in this case.
There's no purge amount in the contempt, so the issue about the ability to pay the purge is not...
No, the court didn't do a purge. What she did on the, it was basically a she determined it as a retroactive alimony payment, in essence. It's like, this is what your arrearage is. And the amount was, I want to say about $220-some thousand and change. And she gave him, I think, a fairly, reasonable payout. Pay it half now within several months, and then the other half 10 months later. So, it wasn't just pay in 30 days or go to jail. Same on the attorney's fees. The attorney's fees were about $38,000 and change. He was ordered to pay those at $500 a month until paid in full. Now, I'm not great at math, but I'm figuring that's a pretty good buyout schedule. I suppose by the time the Huey Magoo's all hit, he'll have the money to pay that. But, so to Your Honor's question, yes, affirmance clearly requires approval of those two elements as well. But even if it didn't, under these particular facts, those rulings stand. For those reasons, we suggest that the court should summarily affirm this case, and I appreciate the court's attention.
Thank you. Mr. Grassley, a little north of 4 minutes.
Thank you, Your Honor. What the theory that you just heard and what's underpinning the trial court's findings, both is an unfair assassination of my client's character, acting in bad faith. He had no clue that he was going to not get a bonus, and he had no clue he was going to get fired. What you just heard was complete conjecture, and that's the quote evidence is the representations of counsel and the questions. And you mentioned the fact that Mr. Korn and I were on other sides of the Gibbs case. Gibbs' trial counsel was the same trial counsel for the appellee here. This is not the first time we've dealt with this. Gibbs, the opinion does not recite enough facts for us to make much of it. The holding that you read that was quoted by the trial judge is simply a conclusion that the records indicate, et cetera, et cetera. There was a whole lot of different issues, and this one, what we're doing here to think we're going to affirm what this judge did is to do an inverted and perverted imputation of income and a dissipation of assets, because theoretically, according to Mr. Korn, my client should have known he was going to lose his job. Well, Mr. Chupp, who was like his mentor, encouraged him to do other investments. He sent sent business to my client's consulting business while they were employed at Lode King. He had no clue that he was going to lose his job. He did not know that he wasn't going to get a bonus. If you go back, and I put this in my reply brief, from 2015 on, he was increasingly making more money each year. And yes, the the 2018 bonus for 2017 work was much larger than normal, but it was consistent with the bonuses he had been receiving all along. The change here is permanent as a matter of law. You would have to come up with some scenario that my client jeopardized his $350,000, what he thought was $350,000 a year salary, total income, turned out to be $250, in order to then go out and have to scramble. He lost 100% of his income. And you'd have to say that he did that in a calculated way so that he could then start from scratch and try to build a business. That just defies logic and common sense, Your Honors, and that's when we start talking about credibility. Fine, the judge makes credibility determinations, but the judge cannot just simply randomly and arbitrarily make up a scenario that this would be a legally an acceptable way to do this. The change has been permanent. It was not voluntary. You can make up all these stories you want and say, well, he should have known he was going to get fired. If he had known, I'm betting dollars to donuts that he would never have done this, because here he is with 2 children in college and a huge alimony obligation. And he loses all of his income, 100% of his income. And he's done nothing but scramble ever since. And Mr. Corn made a big deal about choices. Well, we've never said the former wife doesn't need the money, but she's made choices as well. They both agreed that there was going to be a continued support of their college children, and they lived that. She was supposed to get $20,000, I think, from the sale of the marital home under the consent final judgment. She told my client, no, use that for our son's tuition. When the daughter needs money, wife texts my client and said, our daughter needs X, Y, and Z, and he will pay it. That's why his personal expenses are so high, because he is paying for the daughter. He's not choosing not to pay his alimony over anything other than his child. And he said, I had a tough choice to make, and I chose to do what we promised our child we would do, help her get through college. There is no legal basis on which you can say losing a job was somehow your fault, even though you entered into a consent final judgment, you're stuck with that forever, even though you showed a material change of circumstances. Thank you, Your Honors. Appreciate you letting us have an argument.
Thank you. Once again, always well argued by both sides. Thank you. And
Thank you. Makes it worth the drive.